and contractors should really have mechanisms in place to be able to make sure that notices are served as soon as events or circumstances that might give rise to a delay have occurred.
And as promised to our viewers, when registering for the webinar, we asked you to submit your questions that you'd like to ask our panel members today. So we've got around 15 minutes left of the webinar. So one viewer has asked what the difference is between force majeure and adjustments for change in legislation under Fenwick Red Book 1999. Patrick, you touched upon quite a few times throughout the webinar Fenwick Red Book 1999. Would you care to clarify to our viewers the differences? Just give us a short summary.
Sure. I mean, hopefully this has been largely covered by what was said already, but I think in very kind of brief terms, the force majeure provisions apply to the impact of the pandemic itself. On the other side, the changes in law provisions apply to the kind of steps that are taken and the measures imposed by authorities in dealing with the pandemic. And as we've talked about, force majeure provisions apply when the performance of the works are prevented or become impossible, while the change in law provisions deal more with the situation where the kind of progress has been impacted. The works are still possible, but there have been delays. So while it's possible that both provisions might apply to the current pandemic, which one is applicable will depend really on the facts of the case. Generally speaking, if your project's being suspended or terminated, then force majeure provisions may well be more applicable. But if it's just that progress has been hampered because of the measures that you're having to take to comply with the regulations and so on that are in place, then it may be that the change in laws provisions will be more helpful to you.
Great, thank you very much for that explanation. Hopefully that clarifies the differences there for our viewer. Another person has also said, how should the provision of late information to contractors be dealt with, which the viewer claims has been caused by CV issues? Ahmed, I'll come to you for this question.
If you mean by, or if the question means by late information, late drawings and instructions, for example, they may consider pursuing a disruption claim under the contract. If the contract is, for example, if FEDEC 1999, then you may serve a notice in accordance with subclause 1.9, which will then need to be followed by claim notification under subclause 20.1, and this may in principle give you remedy of extension of time and perhaps additional cost in accordance with subclause 8.4. That's how it works normally, and this general position under most standard forms of construction contract, regardless of the coronavirus, the employer in the circumstances of the coronavirus may then of course defend its position by force majeure argument if they can establish the causal link and mitigation, etc. And then in all cases, I see that in the circumstances, time should be awarded in principle, I think so. But the cost of disruption might not be a straightforward question. This is, of course, a high-level analysis, and careful analysis would be required on a case-by-case basis and specific wording in the contract.
Okay. And another viewer has asked that in the event that a delay notice wasn't served within the notice period, where clients can be denied entry on site, how can you offer an alternative means of recovery? Patrick, I'll come to you for this one.
Well, I assume that means where the contractor has been denied access to site. I think in the context of the 99 provisions, the 99 provisions, notice requirements are very stringent, and contractors should really have mechanisms in place to be able to make sure that notices are served as soon as events or circumstances that might give rise to a delay have occurred. an event of that nature, of actually being denied access to site, is a pretty significant event. So I think I would first of all be wanting to know why the contractor hasn't served a notice given the significance of the event. But equally, I think that given the significance of the event, I'm not sure again whether the access has been denied by the employer or whether the authorities have denied access for a particular reason because of an outbreak perhaps. But either way, it's a pretty significant event, which I imagine would have led to a lot of correspondence between the contractor and the employer. And I would have thought that the employer would have a hard time arguing that it wasn't aware of the event or circumstance having caused delay to the project. I imagine there'd be plenty of correspondence where, which could be deemed to be notice under the contract, where the employer has been informed of the event. So I'm not sure if there's necessarily an alternative means of recovery, but it may well be that the contractor's rights haven't been completely diminished by the lack of notice. But again, it's very difficult to answer that type of question without understanding a bit more of the facts.